Currents.
Thank you, Chair. And yeah, thank you both for outlining the multiple issues with the bill concerning its interpretation of GDPR. I suppose given your expertise and advocacy in this area, the committee would be obliged to include these issues in our report, and I'll be pushing strongly for that. However, let us assume that the Minister doesn't accept the issues that I've raised, and that's a very real concern that I have, and that the bill passes with sections contrary to GDPR. What would happen then? Like, would the people concerned be in a worse position in some instances with new restrictions being brought in? And will individuals be forced to go to court again, and like that case you just mentioned in response to Lynn, to access basic information about themselves? That's for both or either.
So
I'll go first. I'll say to that, as Fred said, first of all, whether or not this bill passes, if it's in breach of the GDPR, the public authorities have a duty to apply the European law and ignore this national law where it is in breach. So that's the first step. Second is, if the public authority doesn't recognise that, then it is liable for two things. One, to be sued by the individual to get access to their rights, and two, to be found to be in breach of the GDPR by the Data Protection Commission, and it can be fined up to, I think, €1 million per instance. So those are the two kind of administrative responses to a failure by the institutions of the state to follow European law. Finally, there's also the case that where the state is in breach of European law and refuses to take action, it's also open to citizens to make a complaint to the European Commission in respect of the failure to comply with European law, and it's open to the Commission to take a case against Ireland, and eventually, we can, as we've seen in environmental issues, you can end up with fines accruing unless and until such time as Ireland brings itself back into line with European law.
So despite the fact that the state might lose, people still may be forced to go to court to access that information about themselves?
In the absence of an effective alternative remedy, that would be the final available remedy.
To come in on these points as well.
I have nothing to say. I think Simon summed it up very, very well there.
Okay. Deputy Kearns, you still have some time left if you want to ask other questions.
I suppose one question that I have is, so if the department goes ahead with the legislation in its current form, if issues that the committee might bring forward in a report, is that in itself a breach that they could be held accountable to, or would it have to be an individual took a case against them in relation to their own information?
In our system, it generally would be an individual would have to take the case to kind of prove the legal point. But I would just say that the principle is that the legislature will not knowingly pass legislation that's in breach of EU law. That's the primary responsibility. So, I think that the committee should be quite strong on that, and that the way to do this is to do it properly and not to have to force people to take complaints to the Data Protection Commission or to litigate this. Like, let's just get it right. We've been at this for a very long time. Everyone knows what the issues are now. Let's just do it properly.
I think and hope that the committee at report stage will make a strong recommendation in relation to all the information that you've given us. And like I said, I'll certainly be pushing for that to happen. Thank you.
Okay, thanks very much. Senator. Deputy Holly Kearns.
Thank you, Chair, and apologies, I was out for Ivana's contribution, so I hope I'm not overlapping. But I suppose we've heard from previous witnesses, including earlier today, that the bill in its current form is contrary to GDPR from some experts. For example, the mandatory information session constitutes a restriction on the right of access and is incompatible with GDPR. I'm wondering if you could provide your perspective on this key issue, and also Head 40 sets out to restrict rights and obligations under the GDPR. So I'm wondering if you're confident that such a blanket exclusion is compliant with Article 23 of GDPR. And then we've also heard how Head 2 of the bill has a list of excluded information, including care provided by a parent or guardian. or the adoptive parent of a child, and that the only information permitted regarding relatives is whether you have a relative and their sex and whether they're younger or older. So just from a GDPR perspective, what are your views on those points? Thank you.
Thank you, Deputy. In respect of our Head 40, that's one of the points I tried to cover in my opening statement, was that the department has accepted the concerns raised by the DPC that the proposed head was inadequate in terms of any restrictions that might be imposed. So in the context of Article 23 of the GDPR, what was proposed, and we said this in July, didn't meet that standard. The department has acknowledged that and is now working to remedy that problem, and so that it will conduct a deep analysis as to the GDPR rights it proposes to restrict, why that's necessary, how is it and proportional and necessary to do so, and to do so in a way that meets the requirements of Section 23. Article 23, sorry, and they will revert to us on that. I also would envisage that such restrictions continue to be a feature of the bill, that it will be a very different head by the time the bill is formally published. So that's positive, and we very welcome the department's hearing of our views in that respect. In respect of information sessions, I just first of all go back to say that the right of access is not an absolute right, and I've referenced Article 15(4) of the GDPR. The right of access cannot adversely impact the rights and freedoms of others, and so, as I said, that's where we understood that the concept of an information session, and the DPC is not casting judgment one way or another whether an information session is the appropriate solution, but it was the mechanism by which we understand that the Minister and Department are trying to ensure that the rights of others are not adversely affected, so that the right of access doesn't need to be restricted. So ultimately it was intended to facilitate the full right of access, so that this balancing of rights could happen in an appropriate way under Article 15. That's our understanding, and I'm not passing judgment on the policy choices within that, but from the GDPR perspective, that's the intention of providing for that framework. And I suppose there's not much more I can really say on that matter at this point, unless there's obviously a further specific question, Deputy, you wish to put to me. I'm sorry, I think you had a third part to your question, which I've just forgotten. Grateful if you could remind me, please.
Yeah, no problem. And just on that, I suppose, be interested to know, is there an example of another scenario where you're entitled to information, but there's something like a mandatory information session that you have to do in advance, or is this an outlier? I'd just be interested to know if that's a common practice. And then the last question was, it's Head 2 of the bill. It has a list of excluded information, including care provided by a parent or guardian or an adoptive parent of a child. So the only information permitted regarding relatives is whether you have a relative, their gender, and whether they're younger or older. So I'm just wondering, from a GDPR perspective, what would be your views on that?
Yeah, in terms of information sessions, I'm not aware of any other such examples, but that's not to say that it's inherently problematic. Again, I'm not passing judgment one way or another on it. It's simply from the perspective of trying to ensure that the right of access is fully respected, in that the rights of other individuals are not adversely affected, that then a controller, or in this case, the department, the minister, is proposing that there should be safeguards in place. And one of the safeguards identified is an information session. It's not to say that some other safeguard wouldn't provide an equally appropriate means by which to ensure that Section 15(4) is respected. In regard to the other point, under Head 2, I suppose the exclusion of certain categories of data. Again, if that's to be seen as a restriction of a data subject rights, and acknowledging that GDPR provides for the restriction of rights, it has to be justified as such. I suppose it's not. It's probably something I would like to reflect on again, hearing maybe some of the comments earlier. But again, in principle, the balancing of what the department is trying to achieve here, it is feasible once the requirements of Article 23 are adhered to. I would also make the point, if something is not explicitly restricted in the Act or in the proposed bill, the GDPR still obviously provides and the rights still stand. So if there's elements of data which it hasn't been explicitly restricted, or other rights not explicitly restricted, or other areas of activity by each of those controllers not restricted explicitly in the bill, and there's no other explicit legislative restriction either in primary or secondary legislation, the GDPR still applies in full to those other areas. So I think a concern was raised if something is, if there's by dint of a restriction in the bill or something captured in the bill, does that mean that other controllers are free of other rights? And that's not the case if it's not explicitly provided for.
Okay, thanks, Mr. Sunderland. We just need to move.
Bill or something, that's not the case.
Marnan O'Connor is next. I'm not sure if she's here. No. Okay.
Chair.
Yeah, go ahead.
Chair, sorry, could I very briefly make one further point in response to Deputy Cairns' comment? I think part of the question under Head 2 is whether the data is personal data at all or not, and that's part of the consideration here, because some information about family members may not necessarily be what the term mixed data. It may not be mixed data, and a relevant body may hold information about family members that is not personal data of the adopted person. So that's a consideration, I think, in play in Head 2, which gives some rationale for the exclusion of some data.
Okay, thanks. Senator Ian McGrahan, you're next.